kaa namna hiyo. Where's your colleague? Namwambia. Oh, okay. I'll see you. Unataka nini chai? Why don't you get a folder? One hour, my friends.
As an interested party, so that I can also express myself, I can also protect my intended rights, especially those rights that have now accrued and which are likely to be abrogated if this petition succeeds. The second point I must demonstrate to you, sir, is prejudice. What prejudice will I suffer if these administrative units are not established? As I've said, it's a direct loss of government services coming nearer to me, and also to the people who are affected and to the people whom I represent. May I start by saying that the petitioners are 5 of them. They are actually swearing one affidavit, which means they have a common interest. And they have not brought any of the beneficiaries as directing parties or as interested parties. What they have done is to bring in government ministries, some of whose role is not clear in this petition, but we leave that for argument when the time comes. It is important to point out that the interested party must be able to bring to this court first-hand information. While the petitioners have sworn a lengthy affidavit raising matters of fact, the various ministries and entities named as respondents are not likely to have first-hand information when it comes to the real issues in the controversy in the petition. This is why, in my view, and in the view of the other interested parties, then we have to come in and give first-hand information to controvert some of the averments, those affidavits, and allegations contained in the petition. Then, the next one I wish to submit on is, would we be of any benefit or assistance to this court? How do we assist the court as interested parties? It is because of the personal knowledge. For me, as a resident of Uragate Sublocation, Uragate Division, Ukogima Sub-County, and the others also in respect of the areas where they come from, in which they also have direct interest. For example, if the affidavits is an allegation that these administrative units are overlapping between the two counties of Meru and Tharaka. Sincerely, this can only be established by a person who has direct information, like me, to show that the creation of Uragate sublocation is from existing villages that have always been in the Tharaka and Tharaka. They have also made claims that there are disputes regarding these areas and frequent fights, which allegations we will allay and controvert. In that these disputes have actually come to an end because we will clearly demonstrate that these villages, these sublocations, divisions, and sub-counties are all from existing regions that are in Tharaka and Tharaka County. In fact, there is no overlapping, there are no disputes, and if there are disputes, these are emergent by the petitioners with a view to deny the people of Tharaka and Tharaka the enjoyment of accrued rights, services and privileges from the government due to the gazettement. I confirm that there has been no delay in bringing this application, and this court has the discretion, after evaluating what we are going to present before you, to determine the matter judicially. And this is why my statement of gross misrepresentation needs to be addressed, and that there is no breach of the direct and accrued rights of citizens in the rest of the area that I represent. Allow me kindly to respond to the replying affidavit filed to oppose, which unfortunately contains arguments which do not directly controvert what I have stated in the affidavit and in my arguments this morning. The whole Arteto case is actually the law on joinder of third parties. One of the bars is there should be no replication between one case by one party and the interested party. Unfortunately, as we speak, no responses have been filed by the respondents, so this court cannot state with any certainty that there would be replication or there would be any dubbing of presentation of matters of fact and matters of law to the court. My role as a member of parliament has been challenged, but my duties include the representation of the people of Tharaka in the parliament, to the executive, and to the judiciary. That is how I have understood my role. While I would do representation in parliament, I would also act as the link between my people and the executive so that they can get the services delivered by the government. This is the reason I say that in fact in the formation of all these units, I participated during public participation by organizing the people from various areas to go and present their views. And it is after that public participation that these areas were established. Number two, may it be known that the petitioners are actually residents of Meru County. And we ask, what is their direct interest in Tharaka constituency and Tharaka County? They would actually have none, apart from what has been described as peripheral interest. They do not reside in those areas. They reside away from those areas, and therefore they are moving in to lay claims, including making allegations that they own farms there, which farms they do not know where they are. Therefore, as far as I'm concerned, I have direct interest because I'm directly affected. In fact, I'm not only directly affected, I am subject to the decision that is going to be made. These petitioners would not be directly affected or even is subject to the decision of this court because they are not residents in those areas. In the replying affidavit, they are saying we can be represented very well by respondents, including the Honorable Attorney General and Tharaka County government, which is actually the first interested party. My response is as follows. Number one, the respondents up to number 8, up to number 7, no, up to number 6 are government ministries and the Honorable Attorney General. These ones will expatiate on policy, the policy that was used to create these areas. The role of the IBC is not clear. There is a water company that is named as a respondent. Again, I don't know what the role is. That will deal with it when the time comes. But when it comes to direct evidence, which this court must listen to in response to the affidavit in support of the petition, that can only be done by third parties. Then it is alleged that the interested parties, some of us, are politicians. I do not know what the weight to that is, nor can I vouch that the petitioners themselves are not politicians. I don't think there is any color or any tongue attached to any person to say you are a politician and you cannot come to court. And unfortunately, whether I'm a politician or not, my rights to closer services by the government are being affected. My representative capacity, closer services to the people of Tharaka constituency are affected. And I will suffer loss and damage if this petition succeeds. Number 2, I will be heavily prejudiced, which will lead to a course of action in my favor that I will actually come to this court. There is an allegation that some of them are mentees and proxies. I leave that to the court. I do not think it weighs anything. And pure application of the law is what we will rely on, but we must also address that application of the law with facts, as we shall put in very detailed affidavits in response to all the facts that are in this. To say that the respondents would actually do this, I think is overstretching, because number 1, the government ministries in Nairobi, there is absolutely nothing found in response, but we expected something to be found in response. And I've said this is going to be on government policy and how they created these divisions, established these administrative units. And at the end of the day, when it comes to everything else said about who lives there, who farms there, whether there are disputes or no disputes, whether this is going to affect the people of Tharaka or not, this can only be done when we are joined as interested parties. This is why we have said, kindly do give us a chance to come before you and lay what we consider to be the correct position, and especially in view of the misrepresentations that have been made in the supporting affidavit. Those misrepresentations cannot be dealt with in this application because they are matters of fact. They will actually be in response to the petition when the right time comes. I cannot be an amicus curiae here because they also admit that I have a direct interest. That is the reason they say I cannot be a friend of the court. I cannot be amicus curiae here because I have direct interest and I'm going to suffer direct loss and damage if this petition if this petition succeeds without my input, without my participation. And we will be challenging every of the facts in paragraph 17, 18, 19. And finally, as I sit down, there's a strange allegation made that the other interested parties are my mentees. That is superfluous. I have not mentored anyone. I have not told anybody to come to court. And in fact, I'm 100% sure they will demonstrate, as I have done, that they are directly affected. They will be directly prejudiced by this petition if it succeeds. And there's no reason that myself, then will show that we are occupants of the administrative units that are being created, and that the petitioners do not have any documents to bring this petition on behalf of themselves and on behalf of anyone else, because they are not residents of Tharaka constituency, they are not residents of Tharaka County. They also made an allegation that Tharaka County would be a good representative of these parties, including myself, and unfortunately, again, that may be presumptive, for as we add these applications today, there is no representation for Tharaka County, and in any event, that is the county. We do not know how it is affected by this. Just the way we do not know how anyone who is not a direct beneficiary of what is being established is affected by it. So matters of we are trying to achieve academic excellence, that again is presumptuous, stretching our imagination. And in fact, as I sit down, I submit that this application should not have been proposed. We should now be getting to the nitty-gritty of the petitions so that we can lay bare before the court the facts as we perceive them, vis-a-vis the facts as perceived by the petitioners. That way, we would be doing justice. The court to shut me out would mean that I have to wait for the determination of this matter, then start studying what my course of action would be and where I will be suing, knowing for sure that I may actually be met with a piece of res judicata if I try to come to this court when the matter is already substantially determined as regards the facts in the issue and the law that is involved. So for those reasons, you pray, my Lord, that you actually allow me to become an interested party in this matter, and after that we can proceed with the rest of the petition as presented. I thank you, my Lord.
The MP for Tharaka constituency and the other applicants in the second application. Your Lordship, at the end of our submissions, we seek to demonstrate to the court that the applicants have not demonstrated any personal stake or interest in the petition and in the issues raised therein. The second point that, Your Lordship, we will be demonstrating is that they have no legal interest or duty in these proceedings, and they are therefore strangers as far as we are concerned, as far as the law is concerned. The third point, Your Lordship, is on the issue of prejudice, that they do not stand to suffer any prejudice should they not have enjoyed in this petition. And the last point will be demonstrated, my Lordship, is that their submissions will be irrelevant to these proceedings and to the issues raised in our petition, and they will be simply be replicating what the respondents will be advancing in their respective cases. And so, Your Lordship, in order to determine how an interested party comes into a matter that is before a court, Your Lordship, we look at the context and the circumstances of the issues that were brought by the litigants. Your Lordship, the context in our case, we are looking at the subject matter of the petition. Also, Your Lordship, what is the subject matter of the petition? We are simply challenging the process and the actual gazettement of the new administrative units in Tharaka County, which we feel they have not defined boundaries since time immemorial, and this has been a recipe for chaos, clashes, conflicts. And I am glad my Daniel's colleague has alluded to that fact of historical injustices. That cannot be denied, Your Lordship. However, as we look at the subject matter of the petition, we are only concerned with the specific new administrative units that were gazetted by the Gazette Notices number at least 1966. And 15341 of 14th February 2024 and 22nd November 2024 respectively. And therefore, Your Lordship, we are asking ourselves, what is the role of the applicants in as far as the subject matter of this petition is concerned? Are they the principal advisors of the Ministry of Interior, which has got the legal mandate, according to Section 14 of the National Government Coordination Act, to actually gazette the new administrative units in the Republic of Kenya? Or are they the principal advisors of His Excellency the President, who, according to that particular section, Your Lordship, is mandated to approve the decision of the Cabinet Secretary for Interior to gazette the units, Your Lordship? And therefore, Your Lordship, as far as the personal interest is concerned and the stake in this whole issue, and looking at the context and the circumstances of this case, the only persons who are at a position to advance their respective cases to controvert our allegations are the concerned ministries and agencies of the national government, and which we have properly named in our petition, so that not one individual person stands to suffer any prejudice as far as the judgment and the orders and the final orders of this honorable court are concerned. Your Lordship, in order to determine that personal interest, the issue of the personal interest of the applicants, we're looking at what stage are they particularly involved or engaged in during the creation of the new administrative units. The only instance where creation of new administrative units interacts with members of the public, such as the applicants in this particular case, is at the point of public participation. Your Lordship, we're not challenging, for whatever reason, the issues of public participation, and actually, Your Lordship, the applicants have shown that they participated. They are in Tharaka County. The petitioners, on the other hand, allege that they have not been consulted despite being affected by the newly created administrative units. These are the units falling at the common border of Meru and Tharaka County, Your Lordship. And it goes without saying that where units are being created where there is a cross-border dispute, parties on both sides must and should be consulted and their inputs put consideration. Your Lordship. Your Lordship, when you look at the theory and the language of our petition, it is based on the institutional decisions. Based on the institutional decisions, Your Lordship. And this petition is purely against the duty bearers who are the various respondents named there, Your Lordship. And since I have listened to my colleagues submit on this issue, allow me to mention the relevance of those specific respondents just for their understanding of the petition before the Honorable Court, Your Lordship. The Ministry, the Cabinet Secretary for the Ministry of Interior is the one with the legal mandate under Section 14 to take views.
That is the second respondent.
Yes, Your Lordship. The second respondent, Your Lordship, is the one with the legal mandate according to Section 14 of the National Government Coordination Act to gazette the administrative units after taking the views of the affected people, or rather the people to benefit from these specific units in terms of service delivery, bringing government services closer to the people. And I believe the applicants have no role whatsoever as far as the second respondent is concerned, and he is the only one who can advance his own case, Your Lordship. The Cabinet Secretary for Lands, Your Lordship, is enjoined as the third respondent, Your Lordship. And Your Lordship, alluding to the historical injustices, what is in contention are the properties, the land, and Your Lordship, Senior Honorable Murugara, Your Lordship, has alluded to that fact that the petitioners are looking after their lands which they cannot tell where it is. That is automatic dispute. But it's not for the applicants to give us the relevance, the coordinates, and the physical location of the properties. The Ministry of Lands will tell us if they have an interest in safeguarding the rights of residents of the Tharaka County and the Meru County as far as properties are concerned, Your Lordship. Ministry of Education, Your Lordship, has also been listed as the third so-called respondent. Just to make the applicants understand, because I know the petition and the affidavit of voluminous, they were unable to go through each and every annexure. Your Lordship, the schools were transferred as a result of lack of this clear definition of the administrative boundaries, specifically the sublocations, locations, sub-counties, and by extension, all the units that fall on that border, Your Lordship. And therefore, the allegations pertaining the schools will be properly responded to by the fourth respondent, and I believe none of the applicants is an agent of the fourth respondent, Your Lordship. As far as the fifth respondent is concerned, Your Lordship, it is for purposes of trying to alter those boundaries that we have mountains, hills, forest blocks being haphazardly gazetted in Tharaka County, whereas on the physical location of the same, they are obscurely in Meru County. And therefore, Your Lordship, these are issues that can only be addressed by the concerned ministry, which is the Ministry of Environment. None of the applicants has even a knowledge or factual basis on how this happened, unless they took part in misleading the concerned agencies and ministries of the national government that are listed as respondents. Your Lordship, the Cabinet Secretary for Health is mentioned, and specifically because of Gitonga Hospital, which is in Meru County, but appearing as if it is in Tharaka County. Again, this is a Ministry of Health that can dispense this. Your Lordship, only the IABC, Your Lordship, and I've taken some time to go through each of these respondents for the understanding of the applicant's Your Lordship. The IABC, according to Article 89 of the Constitution, is mandated to delimit the boundaries and even the number of wards and the constituencies. If a ward or a constituency may be affected by the decision of the Honorable Court upon the final determination of this petition, therefore the IBC will have an opportunity to guide the Honorable Court based on how they will present their respective case. Nidi Water Sanitation Company is implementing a water project on their disputed areas, and the Tharaka County Government and the Meru County Government have been joined as interested parties purely to advocate for the rights of their respective residents. And none of the applicants, I believe, is acting on instructions of any of the respondents to show us how they are personally affected by this particular petition. Your Lordship, the last time we were before your Honorable Court, on 20th of January 2020, this year 2025, the Honorable Gigi did indicate to the court that let us first be enjoyed, and then after that we will be able to make other substantive applications when we are parties and we are addressing his good constituents down there after that case, Your Lordship. He mentioned two very important things. One, that he will ensure that this matter moves from Meru High Court to Nairobi, Milimani. And secondly, that the issues raised in the petition are of with the constitutional, and therefore, Your Lordship, you will be seeking to make an application for constitution of a three-judge bench to determine this application, the petition. That is the sole intention why the applicant, the applicant in the 15th of January 2025 application is so keen to be enjoined in this matter, not because there is any personal interest, not because he's an MP, not because he's a resident of Mukodima, simply to advance his political interests. Your Lordship, on allocation of the applicants in the 13th of January 2025, being the political mentees, Your Lordship, it is true that on 20th when they appeared, the Honorable DG even offered to make an application for them and to speak for them despite lacking such capacity. and defining the necessary documents for the same. These are applicants who are interconnected and who are advancing similar political interests as far as this petition is concerned, against the actual context within which the petition was brought, considering none of the politicians was enjoined with their personal capacity or as a politician in the main petition, Your Lordship. Let me just respond to the issue of Tharaka that has been raised by my colleague, Your Lordship. Indeed, it is obvious that a thief can come into a house and make themselves comfortable. They can even cook there. They can slaughter the chicken. This is what happened, or is what is happening with Tharaka, Your Lordship. But without going to the merits of this particular of the issues surrounding the Tharaka Cultural Center and the issues, those are issues that can be advanced by the various respondents that have been there.
So the first is Paul Mugambi, a resident at Congo, which is contested under 50, as well as a leader of a red group called Tharaka. The second intended interested party, Joseph Binois Zedem, is a resident of the Nosa unit. Is also the MCA for Tharaka in Tharaka County, as well as the deputy majority leader in the same county. The third MCA for Tharaka. Interested party, that is Lukunyaga Marengo, is a resident of Mokozima, which is contested in the petition. Is also the MCA, as well as the majority leader of the Tharaka County. My Lord, the fourth intended interested party, Sylvester Montiri Mokas, MCA Mokozima. The fourth intended interested party, Sylvester Montiri Mokas, who is a resident and the MCA for Gitonga, which is also contested. Yes, Gitonga. And the fifth interested party, who is Julius Ntonja, is a resident and a businessman at Rongo sub-county, which is contested at a meeting. Your Honor, I'd like to draw to the attention of this court that my first and the fifth intended interested parties, they have authority from the residents who are their neighbors to represent their interest in this petition. We filed, I would like to confirm that we filed a notice of motion dated 13 January 2025 in accordance to your directions, as well as supporting affidavits of the said interested parties. The same was responded to by the petitioners, and after that, Your Honor, we filed a further affidavit in response to their reply and affidavit, Your Honor, dated 27th January 2025. Your Honor, it is our submissions on which case we rely the Francis Karaoke Moroteto and another versus Republic and 5 others, 2016, in which the learned judge gave the directions of who an interested party is. Your Honor, to begin with, an interested party holds an interest. They should show locus in which my clients, they are all residents of the contested sub-units. They have built their houses there, they have grown there, and they have lived there for decades. Your Honor, I'd like to bring to the attention of the court, which is a matter which is not in dispute, that there has been historical injustices when it comes to the border of Meru and the Meru. My clients have experienced this firsthand. And so, my Lord, it is my position that they have facts which will help the court to determine on the misrepresented facts they want to shed light to the misrepresented facts. And my Lord, we cannot do that if we are not enjoined as interested parties. The second thing, my Lord, is that one should show that they will suffer prejudice. The intention of creating these subunits, my Lord, is to bring services closer to the people. Being residents and sovereign citizens of the said contested subunits, my Lord, will be affected. And some of the areas which are actually listed like Mokodema, my Lord, I would like to point out that we have Uragate, which is of great importance to my residents, to the residents who are my clients, who hold their cultural festivals. My Lord, if we are not enjoying this petition, then we might suffer by the verdict if it goes against us, in which our cultural, our place where we hold our cultural events, we lose it, and the respondents, it holds not much value to them. But Lord, the other thing is that we should show that we will not represent facts and that we will be relevant. The intended interested parties wherein will submit on facts, first-hand facts, and evidences, shedding more light towards the petitioners are alleging. My Lord, if we rely on the respondents are actually relying on subsidiary facts, which are a matter of records. They have not experienced anything, but rely on what is submitted to them. I know it is of importance to note that we do not have the authority to direct or air out our grievances to the respondents in this matter. These are state organs, and we do not have power at all to give them directions on how to go about the matter. They will rely on their advocates, they will rely on the records that they have, and my Lord, we will suffer prejudice if we are not given a chance to present our case. My Lord, my clients took part in the public participation, which is part of what was attached as an extra in the application. And that proves that they have first-hand information as well as residents. My Lord, I'd like to highlight my response to the replying affidavits, whereby the petitioners are claiming that my clients are politicians. And I would like to draw attention to Article 22 of the Constitution of Kenya, as well as 25, which gives every person a right to legal action, to come to court to seek redress if their rights are violated or threatened to be violated. Your Honor, these are non-derogable rights, and so we cannot limit them by the virtue of their political ambitions or their political office. We are here representing their own interests and those of their neighbors and those of the people who have elected and sent them. And my Lord, if, as the petitioners were alleging that they would as well, if they wanted to make it political, bring the MCAs, my Lord, there is no problem if they do that. No prejudice is suffered at all. However, it is about the willingness of the person and how that person is affected. And it is for that reason that my clients want to represent their issues. My Lord, if we are not enjoined, we will suffer prejudice and we will have no recourse because the matter will already be adjudicated on. We will suffer prejudice and also our enjoyment, the petitioners will suffer no prejudice by asking us. All we want to do is to shed more light to the facts, to present our evidence, as well as help the court by shedding more light. This will give us a chance to have a fair hearing as our case will be heard by this honorable court. I think you may.
To the applications, both applications by the applicants, sorry?
Yes.
My Lord, I would like you to note that there are two issues. All the 6 applicants have stated in their applications that they are bringing before this court. And that is, number 1, that the petitioners have made false allegations in the petition. And that applies to all the applications, my Lord, and the supporting affidavits. And number 2, that all the 6 intended interested parties want to shed light or to set the record straight. My Lord, from the requirements on who can be admitted as an interested party, and the authority is cited by all the applicants, because I believe none of us is disputing the principles under which an interested party should be admitted. We all agree on the principles. My Lord, I don't believe setting the record straight or correcting pleadings by the petitioners is a ground for admission as an interested party. And Your Honor, I would like to draw the attention of this court to petition number 12 of 2013, where the Supreme Court declined to admit the Law Society of Kenya as an interested party.
Petition number
12 of 2013. The court declined in that petition to admit the LSA as an interested party solely for purposes of addressing the flaws in the record of appeal. So if the applicant's sole purpose in this petition is to set the record straight, to shed light because they feel that the petitioners have lied before this court, I believe that is the duty of the respondents in clearing, and it's not the duty of an interested party. Another thing I would like this court to take note of is that the basis to presented by the interested parties for admission as interested parties, interested parties for admission in this petition is because they are residents, my lord. I have heard that from my landed senior, I have heard that from Ms. Wakito, that their clients are residents. So they have told us who they are in names, who they represent, where they come from. My lord, again, I don't believe that passes as an identifiable stake, because I believe the Tharaka constituency, where all the 6 applicants come from, are so many other citizens or residents. The question before this court today, my lord, was very simple, and that is what sets the applicants aside from any other resident in the mentioned constituency. Again, my lord, if the first applicant in the first application, who is Murugara Senior, is here on a representative basis, representing the residents of the Tharaka constituency, is it even representing the first 6 applicants who are also residents of the Tharaka constituency? I note the 3rd applicant in the second application, and the first applicant in the application dated the 15th of January 2025 are both residents, or rather, they come from Mukopima ward, and they all want to set the record straight. They have not told this court what they are going to say that is different from the other. Now, the other thing, my lord, is that this setting the record straight seems to be a very top secret, that they have not told this court. What is it? What is that stake? What is that interest? What is that secret they are coming to tell this court? They were meant to disclose it in this application and in this court, so that the court can make a determination whether that passes as an identifiable stake. But all they have repeated over and over is that they are first-hand experience. They are first-hand facts. We do not know what those facts are. Yet that was the purpose of today's application and the purpose of the case here. And the purpose of these applications, those facts should have been disclosed in that application. Now, moving quickly to the prejudice, they are indicated in the fact. My lord, again, I was constrained as I was going through the supporting affidavits by all the applicants and the replying affidavit. So the further affidavit filed later by, I believe, the first applicant in the subsequent application, who is Mr. Murugara, I believe. And what passes out as a prejudice, as they put it, is that we are going to suffer, or rather our right will be infringed, or this petition threatens our fundamental rights. That is actually what is stated in their affidavits, in those clear statements. Again, my lord, the requirements for admission, and especially on prejudice, in the authority that has been, we have all made reference to, that is petition number 12 of 2013. Prejudice clearly must be clearly outlined in the application. It should not be remote. Now, when an applicant says I'm going to suffer violation of fundamental rights, or my rights are threatened, my lord, I believe the Bill of Rights is very is open to everyone. What they needed to say is what right are they going, what of their right is going to be violated? What is this right that is being created? It is not a top secret. They should have done this code for us to be able to respond. And for this code to actually identify whether indeed there is any such rights that will be violated by this petition or by the orders this court is going to do. Those rights have not been disclosed. Again, just like they are first and facts, they seem to be very top secret. Yet today, was the purpose for that? For them to disclose. They have not disclosed anything. Now, I tend to believe that my colleagues have actually rather misunderstood the second requirement for prejudice, because they say if they are not admitted in this application, they will not continue getting services from those administrative units. So they are understanding that the prejudice they are supposed to demonstrate is what prejudice they will suffer if the administrative units are not deliberated. My Lord, the requirements is very clear. You are supposed to demonstrate. They are saying that they are going to suffer prejudice if the administrative units are not deliberated, or rather if this court was to stop or set aside the gazette notices. But then the requirement is, what prejudice are they going to suffer if they are not enjoyed as interested parties? That is the question. And that's why it took time to pick out what they have indicated in their affidavits as to what prejudice. And how I could find is that their rights are going to be violated, which I've told this court, the right has not been disclosed. But then, if their fear is that if these administrative units are stopped by this court, they are not going to get services, I think we have an answer in their own supporting affidavits. And I want to quickly go to one of the supporting affidavits because they all say the same thing. I want to choose one specific one, not supporting affidavit, but rather the application dated the 13th of January 2025, paragraph H of the grounds. On that paragraph, the applicants state that the newly created administrative units are merely an upgrade of existing lower units. Your Honor, what that ground discloses is that actually they are pre-existing units, which if the current units that were gazetted, that the petitioners are challenged, if the current gazette notices are quashed, the applicants will continue receiving services from the pre-existing units. That is their own ground. It is that role is there that they will not stop receiving these services. The petitioner's issue is with the units that overlap into their areas of residence and for which they were not consulted at the point of their elimination, and for which they suffer a lot of confusion because they do not know to which office to go for those services. That is the point. You know the applicants, my Lord, have told this court that their submissions will not be a replica of what the respondents will have to tell this case. My Lord, I do not want to repeat what my colleague, Mr. Irida, has said, but I would like to go back to the requirements. That is the third requirement of admission of an intended interested party. And my Lord, the requirement, the third requirement is that the applicant must set out a case or submissions it intends to make before the court. One, demonstrates the relevance of those submissions. To show that those submissions will not be a replication of what the respondents will come to say. My Lord, I must first begin by saying, looking at all the applicants' applications, nobody discloses what submissions they are going to bring before this court in relation to the petition. However, since we have a duty to this court and to the public, we have looked at the annexed documents that Counsel is going to get referred to, which is minutes of public participation, And my lord, if that is what the intended interested parties then intend to come and tell this court, that they participated in the public participation for the elimination of this unit, my lord, we are simply saying the petitioners are not challenging their participation. The petition itself has not challenged the participation by the intended interested parties to the alleged public participation. What the petitioners are saying is that if indeed there was public participation, which is the prerequisite for the elimination of these units, they were not involved, then that public participation was not adequate, it was not proper. So basically the issue the intended interested parties want to come and address this court on, apparently, is not an issue in this case. Again, Your Honor, I'll try to use a very simple example that anybody here can understand. If there was an accident along this road today, and somebody witnessed the accident, my lord, there will be a witness. They cannot be the victim if they were not hit by the motor vehicle. They are not the driver who caused that accident. They are not the owner of the motor vehicle who would be vicariously liable. And they are not the insurance company that is expected by law to indemnify the victims. They will be simply witnesses. Now, if the intended interested parties, as they say, participated in the public participation, it is for the duty bearer, who is the Ministry of Interior, who has the obligation to demonstrate to this court they adequately performed public participation, and then it will be their obligation to call the intended interested parties as witnesses to come and demonstrate that they are participants. A witness cannot purport to come and prove a case that has not been made. So, my lord, I believe the intended submissions by the interested parties have no relevance to this matter until they are called as witnesses by the relevant duty bearer. And it won't be anything different that the duty bearer himself or themselves won't come and tell this court. If the duty bearer conducted public participation, they'll come and tell this court, we conducted public participation. So if the intended interested party intends to come to this court and tell this court, I participated in the public participation, how is that different from what the duty bearer will come and tell this court? So we are saying the submissions will not be any different. Again, my lord, they have said that the respondents will not properly ventilate their case. My lord, under Article 156(6) of the Constitution, the AG, one of the duties of the AG is actually to represent the public interests of the Kenyan people. The intended interested parties are Kenyans from Tharaka County. The AG has entered appearance. We believe the AG will adequately address their interests, if at all any. You are looking at the gist of the petition before you. The petition before you is not about the historical differences. Those are not the subject of the dispute. It is the subject of the dispute. It is the delimitation of the boundaries, the decision-making process. Was it properly done? So we believe that AG, whatever interest the intended interested parties may have, will be adequately addressed by the AG and the interested parties who are the Tharaka County Government and Meru County Government. with that, I beg to submit that the applications by the intended interested parties have not met the threshold for admission before you hear. They are simply meant to come and read our case through this court, of course. And we ask this court to decline that invitation. I saw something.
The prior observation by counsel, he should restrict himself to the points of law, not the facts and evidence.
There is no way there's not a page of law without relating to the facts. Absolutely. Because the argument is the 6 interested parties, intended interested parties, have absolutely no locus to be here.
They're saying they are no locals.
Yes.
Your Lordship, he is making an application here, even without being a party in the case itself. Or the issue of the locus, that's a substantive issue for the petition.
What is the argument? That these people,
If I get you, you are responding to the issue of the locals.
locus,
That
yes.
has been raised by the
By that the 6 of us have no locus to be here, and our interests would actually be represented by the first to the 6 respondents. And I'm saying the converse is also true.
I think that's a valid point.
Yeah, but the petitioners who have actually no business being here, they should have gone to the first to the 6th respondents to validate what they believe is their case. Therefore, if they are here,
Yes, I've recorded that.
yeah,
If the petitioner is the argument and the same argument applies to the
absolutely. It applies to the petitioners too. They should not be in fact. Another point that has been raised.
But you don't go to the fact. I think that's a point of law.
Yes, that's a point of law. There is a point of public participation, Article 108 of the Constitution, which a distinction is trying to be drawn on 2 issues. 108 makes a provision that for any arm of government to make a decision, especially the legislature and the executive, there must be public participation. The point being made by the petitioners is that they did not participate during the public participation. The point being made by the interested parties is that they participated. So the question is, the petitioners being residents of Meru, how, which they should actually explain, how would they have participated regarding matters in Tharaka County? They would not, even by any stretch of imagination. So this is why we are saying, allow us to come in. It is said that our interests can be represented by the first to the 6th respondents. But these are the matters which we have first-hand information and evidence, which we have to give to the court. And I have also stated that the petitioners do not have any first-hand evidence, because they are not residents of Tharaka County. They are residents of Meru County. So, when it comes to demonstrating direct interest, I confirm that applicants have satisfied that arm. The last one was on prejudice, relying on the Rateto case. Prejudice. My Lord, even if we go whichever way, if these orders are successful, who is the direct consumer of those orders? It is not first respondent to the 6th respondent, to the 8th respondent, or to the first and second interested parties. The consumers of those orders will be the 6 interested parties and those they represent. It does not matter if an argument is made that some of these are on existing administrative units. The fact remains, a new sub-location is nearer to the people. A new location comes nearer to the people. a new division comes nearer to the people, and a new sub-county comes nearer to the people. To say we will continue enjoying from the previous units which have been in existence means we are back to where the complaint was when we did public participation, that we wanted these units near us. In any event, on their own admission and shooting themselves on the foot, they have admitted that the older units existed in the Tharaka constituency and Tharaka County. How come those units were not objected to that time? This is a pure afterthought. We urge you to allow us to come in. In fact, we will have a lot more to say than we have said this morning and this afternoon. Kindly, my Lord, join us as interested parties.